A woman is in jail and all of her children are in state custody after her 2-year-old allegedly overdosed on drugs. We sit down with retired Ohio Judge Fanon Rucker to talk about the investigation, her legal case, and what we can expect next. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. All right, let's talk about this very troubling case out of Ohio where a mom of 4 is now in custody after one of her children was rushed to an emergency room for exposure to drugs. The Guernsey County Sheriff's Office says that they were notified by social workers at a children's hospital that a 2-year-old was being treated for exposure or overdose from amphetamines. Deputies say 29-year-old Brittany Colvin took the child to a medical center in the Cambridge, Ohio area around 11 p.m. on April 27th. And after the child was stabilized, the child was then transferred by medical helicopter to Nationwide Children's Hospital in Columbus, understanding it's about an hour and a half away by car. Now, according to the sheriff's office, Colvin didn't show up at the hospital, didn't show up at Nationwide Children's Hospital. And officials couldn't reach her. And this, by the way, while her child was listed in critical condition. Having said that, deputies, they were finally able to track Colvin down. And around 9 a.m. the following morning at an apartment complex in Byesville, she allowed the deputies to enter the home where they found her 3 other small children, one just over a year old, 2 one-month-old twins. Law enforcement says that they removed the children because of the condition of the home. Now, we don't have further details on what that condition is, but given what has reportedly happened to one child, we can only imagine. These children reportedly all in the custody of Child Protective Services. Colvin was taken into custody, charged with felony child endangerment and tampering with evidence. According to the court records, quote, complainant being duly sworn states that Brittany Nicole Lynn Colvin in Guernsey County, Ohio, on or about April 25th, 2024 through April 28th, 2024, unlawfully was a parent, guardian, custodian, person having custody or control, or person in loco parentis of a child under 18 years of age who did create a substantial risk to the health or safety of DW. Those are the initials of the minor, and the date of the birth is listed as well. And she did this by violating a duty of care, protection, or support in violation of the statute. Records also state that Colvin, quote, on or about April 28th, 2024, unlawfully did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation in violation of the statute. That's the tampering with evidence charge. Now, there's nothing in the sheriff's office press release or court paperwork about what specific drugs may have been involved here, whether Colvin herself was using drugs or if anyone else in that home may have been using them. The sheriff's office did say that Colvin's boyfriend was also interviewed. It's unclear if he was arrested as well. Colvin appeared Tuesday in court for a bond hearing. Her bond was set at reportedly $250,000. 10% of that would have to be put up as collateral for her to go free pre-trial. At last check, though, she's still behind bars. Preliminary hearing scheduled for May 6th. Let's talk about this right now with attorney and retired Ohio Judge Fanon Rucker. Judge, thank you so much for coming on. Really sad case. What's your take on it?
Hey, Jesse, glad to be here. You're right. Sad case. I mean, and it's unfortunate how frequently we see cases like this where, mothers, young fathers who are in the throes of addiction and really unable to navigate life.
Just to be clear, we don't know, right? We don't know if there were addiction issues here. We know that there was the presence of this drug, or at least that's being reported, but we don't know if she was abusing the drugs, how this child got access to it. I mean, I think a fair assumption would be that could very well be a possibility. We just don't know for sure.
Sure. And what I'm suggesting is that the sadness of these types of situations when we see them generally involves, younger folks who have these issues, who haven't figured out how to navigate them. And unfortunately, the worst victims of these poor decision-making processes of these folks are these innocent children. I mean, how frightening must it be for that child to not only go through that, but to go through that alone, to have these strangers around them, and and their mother not being right there by their side, as we know that she wasn't, because they were out looking for her and couldn't find her, and when they did, they end up locking her up and taking the children out of the home. It's sad. It's very
It's
the entire scene is heartbreaking.
and such young children, young mother. It's a disappointing situation. I mean, I will say, thank goodness she took this child to be taken to be treated immediately. Because how many cases have we covered where a child could be left for dead after getting sick like this? So the fact that she did apparently take the child to emergency services, I mean, that in and of itself was a great thing.
That's right. That's right. And you were talking about the fact that she was charged, and the complaint indicates the conditions of the home was such that prompted them to charge her with child endangering, to remove these children. When I was a prosecutor and certainly as a judge, I saw so many cases where, again, the conditions of the home, you see these photographs and you'd ask the question, how in the world can a family or individuals live in these types of conditions? And although we don't have the pictures, I know those descriptive words and I understand the scene, and I can only guess that those same conditions apply here. And you have to ask the question, why, if you need help, don't you ask for help?
And
Because that's a lot of these instances that help is available and people just don't have the capacity to ask for it.
what do you think those conditions were?
Well, excuse me. Again, looking on past experiences with these types of cases, the houses are generally extremely cluttered. There's generally some types of infestation in a lot of these types of cases where people are living. Sometimes there's a lack of food. Sometimes there are drug instruments lying around the house. And if we know that this child ingested some type of drug, we know that there is some instrumentality of ingesting those drugs that was somewhere around the house. Whether that was needles, we don't know. Whether that was pipes, we don't know. Whether that was just baggies of some type of drug that they had readily access to, meaning it was somewhere within hand's reach of these children. But that's what we can presume the conditions are because of the complaint and the way that it's drafted and the way that these cases are generally charged here in Ohio.
Let's talk about the law a little bit. This child endangerment charge, to be clear about it, this is just creating the environment for something like this to happen, right? It's not that she intended to cause her child to ingest or be exposed to the drugs, right?
That's right. The charge indicates that a person created a substantial risk of physical harm. They created a substantial risk. Now, sometimes people are charged, and again, as a prosecutor, I was involved in the cases where people were charged where nobody was harmed. There was no harm actually caused to the child, but the risk existed. The risk existed because they left home and didn't come back for 12 hours because they were out at a nightclub. The risk existed because there were conditions around the home that could have resulted in the child grabbing something off of a counter or grabbing a gun. Fortunately, in some of those instances, the risk was created, but fortunately, the child wasn't harmed. Here, we have the substantial risk, and unfortunately, we also have the harm that was caused, which substantiates the fact that there was a substantial risk. Evidence, the child was harmed as a result of the risk that was created.
And really sad, disturbing case. Makes you think about how the world is sometimes just not an easy place. And one of the scariest things that can happen is if you get injured. It's incredibly traumatic. It's a confusing time. But that's why I want to take a minute to call out our great partner and sponsor, Morgan & Morgan. This is a firm that you would want in your corner because they are specialists in this area. Morgan & Morgan is America's largest injury law firm, and for a reason. They win a lot. They have secured multi-million-dollar verdicts and settlements. In fact, they secured a $120 million verdict in one of the first personal injury trials post-pandemic. And by the way, in that case, there was a pretrial offer of just $20,000. Yeah, Morgan & Morgan, they don't settle for lowball offers. They will fight to protect your legal rights and for what you deserve in compensation. But one of the best things about Morgan & Morgan is how easy they make this whole process for their clients. From submitting your claim to uploading documents to signing contracts, talking to your legal team, it can all be done from your smartphone. That's it. Seeing if you have a case only takes a few minutes. And you know what else? There's no upfront fee. You only pay them if you win. So if you're injured, you could start by easily submitting a claim at forthepeople.com/LC sidebar or by dialing pound law. That's pound 529 on your phone. My understanding is she's currently facing one count of that. Is there a chance she could be charged with multiple counts of child endangerment if they look a little bit more into this?
That's right. She could. You can technically charge as many of children who could be harmed as there are in the home, even if they're not her own biological children. Say she's taking care or someone's taking care of nieces and nephews or neighbors. If they're the one in care, custody, or local parentis, as the complaint offers, then that person can be charged for any number of those children who are in the home and who are exposed to that substantial risk.
How do you defend yourself from something like that? It seems pretty straightforward. A lot of the cases that we cover where you have a child victim, it's different than having an adult victim. There's context, you have to understand the relationship between the two. What was the victim doing? This is a helpless child. I don't defending these cases, in my experience, has been very, very difficult. How do you defend it?
Well, sure. I mean, each element has to be proved by proof beyond a reasonable doubt. So what's one of the biggest elements is, was she the custodian? Was she in local parentis? Or did she give that responsibility to somebody else who was expected to take care of the child? They said that the father, or a father of at least one of the children was interviewed. Was he supposed to be taking care of the child at the time that this happened? Did she seek some assistance that was supposed to be provided? And so when the child was actually harmed, there was somebody else who was in a position who was supposed to be taking care and watching over the children at that time. Was she in the process, quote, of organizing some things? Again, we don't know exactly what the conditions are. I assume that the law enforcement officers who were diligent in their duties took plenty of photographs and video of the conditions so that they could present that evidence in court. And so how extensive are the horrible conditions will be a point of defense. Maybe it was, a very sensitive officer who said, there's no milk in here, and that's a substantial risk of physical harm. I don't believe that's necessarily the case.
Right.
Depending on what the evidence is and what the basis of that substantial risk is, that's how it's attacked. Number one, whether she was the person who was supposed to be watching the kids at that time. And number two, how poor were these conditions? And, is that, did they actually create a substantial risk of physical harm, or was the child injured by some other mechanism that caused them to be injured?
Yeah, and I just looked back at the court paperwork, and it seems that this is a child endangerment charge with only respect to one of the children. So I would be curious to see if there's going to be more with respect to other children. Let's talk about the tampering with evidence charge. What do you think that's about? It's not just that she didn't show up at the hospital. Is there something more there? It sounds like she literally tried to discard evidence or allegedly discarded evidence to make sure that she wouldn't be arrested or prosecuted. Isn't that what I'm getting at here?
You have to wonder, when they couldn't find her, when the child was being transported by air care, because they were in critical condition, they couldn't find her. You have to wonder if through interviewing and through diligent police work, they were able to discover that she was, in fact, during that time, trying to get rid of perhaps some of the evidence that was the drugs that the child ingested that caused the child to be in critical condition. Or she was getting rid of some other evidence that she believed or knew was going to ultimately be discovered or could be potentially used against her in the prosecution of this case. You have to believe that may be the source of the tampering with evidence. But because they didn't specify it in complaint, again, that is still speculation, but they go together.
That's a really, really good point about what might have happened there. My understanding is third-degree felonies, looking at potentially 9 months to 3 years in prison. Am I right about that?
That's right. That's right. They are in Ohio. fourth and fifth degree felonies are the lowest. Fifth degree felony is essentially the highest level of misdemeanor, plus a few more extra months. A third degree felony and fourth and fifth degree felonies have a presumption of probation or community control.
Yeah.
When you get to felony threes, there still is a general presumption of community control. However, there is also a justified basis for a significant amount of a period of incarceration. And with the felony threes, she'll be looking at that potential time.
Do you think that there is a possibility, and in your experience, have you seen plea deals worked out in these cases, and what would that look like?
Well, of course, as I tell my clients on both sides of the table, there are no guarantees in any litigation, whether that's criminal or civil. And so the best outcome is an agreed outcome. And so that's why we see a lot of plea deals, because the defense recognizes that there's a risk that their client will be convicted before a jury. And the prosecution is willing to negotiate a plea because they recognize that there's a potential that even though they have the strongest case they believe they can bring, that a jury or a judge is going to, based on legal grounds or based on some errant testimony, lose the case. And then there are no consequences. There's no ability to impose some restrictions or to assist the defendant in getting some assistance so that they're not back here when they get those kids back. And so, yes, certainly a plea deal would not be a surprise if it gets worked out, potentially after we understand what the basis of the evidence is. Both sides have risks, and the side that has the greater risk will be more inclined to seek a plea deal than the other.
Now, I understand that the details of this are limited in terms of what we know, but having said that, based on what we do know right now, would you say that prison is an appropriate punishment for this mother in this circumstance?
Well, there's a lot of unknowns, and one of those unknowns is prior history. Do we know whether or not she's had run-ins with the law like this in the past? Do we know if she has any prior convictions for child endangering or for tampering with evidence? Because that would seriously color the decision about whether or not jail time is likely or whether it would be appropriate. Obviously, if this is a first time offense and, she just hit a rough patch in her life in the past couple of months that can be verified, then jail time would be less likely, because the idea that she can dig herself from this hole with the assistance of the court, with the court programs and community resources, makes jail kind of, unnecessary and overhanded if the objective is to protect the child and to ensure that this doesn't happen again. We pray that that child does get better. And because what we also know is, although she's charged with what she's charged with now, if heaven forbid the child's condition deteriorates, certainly the charges could and most likely would be upgraded.
Unfortunately, you are 100% right. We hope that doesn't happen, and we are wishing for the safety and health of all of those children. Really, really sad case. Judge Fanon Rucker, thank you so much for coming on. Really appreciate it, and always giving your perspective. Really, really great insight. Thank you.
Thank you. Great seeing you.
And that is all we have for you here on Sidebar. Everybody, thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.